Hi friends, welcome to Novation. I'm Shantanu and I welcome you all to this important session of Static GK जिसमें हम लोग Polity and Constitution पर कई सारे MCQs discuss करेंगे. And friends, I request you to please attempt the assignment question which will be at the end of the session. Also, this will be the part 2 for the previous video that I have made on Polity and Constitution. Please do watch it also. I'll put the link in the description section, and also you can find the link on the topmost right corner of your screen. Further, I want to pass down an important communication to TISSNET aspirants. So that communication I'll give at the end of the session. Okay, so without any further ado, let's start this session. The first question for today: in 2019, the government introduced 10% reservation for economically backward section, that is EWS, in general category, under which constitutional amendment and which amendment bill. So friends, हमको बताना है कि EWS लॉ जो पास हुआ था 2019 में ही, वो किस कॉन्स्टिट्यूशनल अमेंडमेंट के अंडर हुआ था और उस बिल का क्या नंबर था, which was the what was the number of the amendment bill. So friends, it was 103rd amendment in constitution and the number of amendment bill was 124th amendment bill. So friends, it's a very recent topic, so please isko yaad rakhiye. Let's see the points to know. So after an over 4.5 hours of debate, 323 Lok Sabha members voted in support of this bill and only 3 people voted against this bill. Okay, so it's an important bill. Please do note down the amendment number. It is 103rd constitutional amendment and the bill was 124th constitutional amendment bill. आगे बढ़ते हैं. For how many years a person should have practiced in a high court to be eligible to be appointed as the judge of Supreme Court of India? So friends, the question indirectly asks you about the qualification of a judge of Supreme Court. So friends, the rule is that the High Court, the Supreme Court judge should have practiced for around 5 years, that is for 5 years in a High Court, or let's see other qualification. He should be a citizen of India, and if not 5 years as a judge in High Court, he should have been an advocate of High Court for 10 years. So either of the qualification will work. Either you are 5 years as a judge of High Court or 10 years as an advocate in the High Court. The Chief Justice of India and judges of the Supreme Court are appointed by the President. So you need to know this also, that the judges of Supreme Court and also the CJI are appointed by the President of our country. Moving forward, which of the following states has the maximum number of seats reserved for scheduled tribes in Lok Sabha? So friends, इन स्टेट्स में से कौन से स्टेट में लोकसभा के लिए शेड्यूल्ड ट्राइब्स, दैट इज ST कैटेगरी के कैंडिडेट्स के लिए सबसे ज़्यादा सीट रिजर्व्ड होती हैं? सो द करेक्ट आंसर इज डी, मध्य प्रदेश. मध्य प्रदेश में कितनी शेड्यूल्ड ट्राइब सीट्स हैं वो देखते हैं. सो इट हैज़ 6 रिजर्व्ड सीट फॉर ST कैटेगरीज, एंड अगर हम SC कैटेगरी की बात करें तो उसमें सबसे ज़्यादा सीट्स रिजर्व्ड हैं. दे आर रिजर्व्ड इन उत्तर प्रदेश. बी, उत्तर प्रदेश, इफ़ द क्वेश्चन वॉज आस्किंग SC सीट्स. Okay, 17 seats are reserved for scheduled caste candidates in Uttar Pradesh for Lok Sabha. Moving forward, what is the tenure of Vice President of India? So friends, tenure means जब वो पोस्ट को लेते हैं तो कितने साल तक continuously he can be at that post. एक टर्म में कितने साल तक वो उस पोस्ट पर रहते हैं. So that is tenure. So the tenure of Vice President of India is 5 years. Very easy. And for the president also the tenure is 5 years, and also you can say that the prime minister is also elected for 5 years only, and he can be the prime minister until and unless he is able to prove that he has the majority in Lok Sabha. Okay, moving forward, which article of the constitution grants constituent power to make formal amendments and empower parliament to make to amend the constitution? फ्रेंड्स, कॉन्स्टिट्यूशन में कुछ भी चेंज करना है, यानी कि इफ़ यू वांट टू अमेंड द कॉन्स्टिट्यूशन, विच आर्टिकल हैज़ दैट प्रोविजन? द आर्टिकल इज आर्टिकल 368. प्लीज डू कीप इट इन माइंड सिंस दीज अमेंडमेंट come under this article, so it can be very well asked in the exam. So as I told you, article 368, which is in the part 20 of constitution, deals with the power of parliament to amend the constitution and its various procedures. So do remember the part and the article number. Moving forward, Which of the following articles provides the right to constitutional remedies? So friends, that's a very important fundamental right. So under which article this right to constitutional remedies come? It comes under Article 32. Okay, so the answer is B, Article 32. Right to constitutional remedies, which means that a person has right to move to Supreme Court or to High Court. So friends, any of us, if our rights are getting violated, we can get remedial action through courts, Supreme Court or High Court. Generally, first we go to lower courts, then to upper courts for getting his fundamental rights. Article 32 was called the soul of the Constitution and the very heart of it by Dr. B.R. Ambedkar. So Dr. B.R. Ambedkar, the chairman of the drafting committee of our Constitution, said that this right is the basic heart of our Constitution. Okay, moving forward. Next is another important, I would say, which of the following writs literally means to have the body of. So friends, हम देखते हैं writs क्या होता है. So which of these writs means to have a body of? The answer is B, habeas corpus. Okay, let's see what writs means. So anything that is issued under the authority is a writ, and these writs are issued by the Supreme Court, and it will include orders, warrants, directions, etc. issued under authority are the examples of writ. And there are 5 major types of writs that are issued by our court, that is habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So friends, these are the 5 important writs, and you need to know the meaning of each of them. And here habeas corpus is the literal meaning is to have the body of. And what does this habeas corpus writ means? That is, the court commands that anyone has to be produced in front of the court. He has to come with his body actually. So in body, the person has to be present in front of the court. Either it can be an individual or even the government. The court can summon them. Okay, so that is habeas corpus. Please go ahead and read about mandamus, prohibition, quo warranto, and certiorari. Okay, so that is kind of a small assignment that you have to do. Moving forward, the maximum number of candidates which can be catered by a single EVM, electronic voting machine. So friends, candidates here means the person who are standing in the election. So one EVM can handle the maximum of 64 candidates at the same time. So you might have seen, I hope you all guys must have voted at least once. So there is this voting pad. There are around 16 candidates on one pad, and if more than 16 members candidates stand in election, then what they do is one more balloting unit is connected in parallel to the first balloting unit. So that's how a maximum 4 balloting units can be connected together, so that 16 into 4, that is 64 candidates can contest an election and people can vote for them. I don't think so such a lot of people do stand in election, but if any contingency arise, the people in the polling booth can do this, and maximum, the answer is 64. Moving forward, next is, which of the following sections of IPC, Indian Penal Code, deals with sedition laws? So friends, sedition means when via various media like written media or visual media, you spread such words that are that try to break the country or to dethrone the government, that is called as sedition. So there are certain colonial rules which are called sedition laws in India, and under which section do they come of IPC? They come under 124A, section 124A. And why am I calling it colonial rules? Because sedition in India is defined by section 124A of IPC, and this section 124A was introduced by British colonial government in 1870. So friends, as I told you, it is a colonial era rule, and it can be a good topic for discussion in your GDs, which you will face in the coming months. That should the government abolish this colonial era rule IPC 124A, or should it remain in the constitution? So it can be a good topic for discussion. Even Congress in its general election manifesto said that they are going to scrap this sedition laws. So I want you guys to think about it and try to make your own opinions by reading various articles and understanding each and every point of view. This can be a good topic for GD. Moving forward, what is the total number of languages added in the 8th schedule of Indian Constitution. So our Constitution recognizes how many languages? It is it is C22. And originally there were 14 languages in the Constitution. So friends, before this various amendments, there were around 14 languages in the Constitution, and then further many are added after the amendments. So let's see one by one. 21st Amendment of 1961 added Sindhi. 71st Amendment of 1992 added Konkani, Manipuri and Nepali. And 92nd Amendment, the final one, added Bodo, Dogri, Maithili and Santhali in the language list. And there is certain news that maybe Bhojpuri can also be added in certain time. So let's see if it gets added or not. Okay, moving forward. Next is the implied right to privacy is a part of the right to life and personal liberty enshrined under which among the following articles of Constitution. So friends, though right to privacy is not explicitly mentioned anywhere in the fundamental rights, it is still implied by the fundamental right to life and personal liberty. And it is mentioned under which article? It is mentioned under Article 21 of our Constitution. Let's see what are these different Article 19, 18 and 20. So Article 19, very important, I would say. It provides various freedoms to us, like freedom of speech and expression, assemble peacefully without arms, form association and unions, very important for TISSNET aspirants, free movement, reside and settle, practice any profession in the country. So these are the freedom we enjoy in our country. Article 18 provides the right to abolition of titles and create artificial social barriers. So there will be no given title in a society which can create discrimination between one class and other class. And the last, Article 20, it provides protection in respect of conviction for offences. So these are the important articles which I guess you might be writing. Moving forward, next is the President of India addresses, so this should be addresses, his resignation letter to the. So friends, if such a situation arises that the President wants to resign, then he can address his letter to whom? To the Vice President of our country. Let's see the PTN. So the President of India may, by writing under his hand, address to the Vice President, resign his office, as I told you. And President of India presently, who is the President, friends? He is Honorable Shri Ramnath Kovind. So do remember, these are very small questions, might not be asked, but these are really important for interviews. Moving forward, the Central Right to Information Act came into force in which of the following years? So friends, Right to Information RTI Act, it was enforced in which year? It was enforced in year 2005. Let's see the PTN. So RTI is a part of fundamental rights under Article 19(1) of the Constitution, and this law was passed by Parliament on 15th June 2005 and came fully into force on 12th October of 2005. Okay, so you can remember the year only, don't need to remember the whole date. Okay, moving forward. For how many terms can a person become the Prime Minister of India? So friends, here terms, I'm not asking the number of years. Terms means successive 5 years in office. So how many terms can a Prime Minister have? Friends, there is no limit. A person, if he is enjoying majority in Lok Sabha and supported by his party, he can be the Prime Minister of our country for as many years as he wants. Same is the case with President. There is no limit to the number of terms one can become the Prime Minister as long as the party enjoys majority in Lok Sabha, or the same is applicable to President. As I told you, moving forward, which article of the Constitution empowers the President to grant pardons to persons who have been tried and convicted of any offence? So friends, you know that the President of our country has the power to grant pardon to certain convicts. This question I have put in the session because recently due to the convicts of the Nirbhaya case have gone to the President for their pardon plea, but President has rejected. So that's a good development. And so which article, under which article this power of granting pardon is provided to the President? It is provided under Article 72 of our Constitution. So Article 72 says that the President shall have the power to. So pardon की क्या क्या power है President के पास वो देख लेते हैं. सो पार्डन इट विल बी मीन्स कंप्लीट पार्डन, उसमें कुछ भी सज़ा नहीं होगी. नेक्स्ट इज रिप्राइव, दैट इज टेम्पररी सस्पेंशन ऑफ द सेंटेंस. कुछ समय के लिए उस जो सेंटेंस है उसको टाल दिया जाता है. रिस्पाइट, दैट इज अवॉर्डिंग लेस सेंटेंस, थोड़ा सा कम करके सेंटेंस देना. रिमिशन मीन्स रिड्यूसिंग द अमाउंट ऑफ सेंटेंस, अगर सज़ा ज़्यादा है तो उसको थोड़ा कम कर दिया जाएगा. नेक्स्ट इज कम्यूटेशन, दैट इज changing one punishment to another, so that can also be done by the president. These are the 5 power under the article 72. Moving forward, which of these constitutional amendments lowered the voting age of elections to the Lok Sabha and to the legislative assemblies of state from 21 years to 18 years? So friends, कुछ सालों पहले only after 21 years of age we can vote, but now 18 years of age, the people who are 18 years of age can vote. So under which constitutional amendment this happened? It happened under the constitutional amendment of 61st constitutional amendment. And in which year? In 1988. And this was enacted keeping in view the literacy, enlightenment and political awareness of the youth. So these are the reason why this amendment was brought about. Moving forward, under which of the following conditions can President of India declare a financial emergency? So friends, there are 3 kinds of emergency that can be applied in our country as per the constitution. So one of them is financial emergency and the other 2 are national emergency and state emergencies. So financial emergency कब president impose कर सकता है? When he or she feels that there is a threat to financial stability of our country. This is the condition for financial emergency. And friends, national emergency कब apply होती है? जब president को लगता है कि there is some huge threat to the nation. For example, there can be war or there is huge disturbance inside the country. So in such cases emergency can be applied. And also when there is some problems in the state, like the government fails, for example it happened recently in Maharashtra. So these are the cases when emergency can be applied. And the president under the article 360, so the emergency provisions are in under article 360 of the constitution, has the power to declare financial emergency. And India has fortunately never seen an financial emergency. So we haven't seen a financial emergency up till now, but we have seen national emergencies, which you might be aware in the regime of Indira Gandhi also, and during some wars. Moving forward, who among the following was the second president of India? Since we have put up the picture, it is quite easy to understand. He is Dr. Sarvepalli Radhakrishnan. He was the second president of India. And who was the first one? First one was Rajendra Prasad. Moving forward, who among these declares if the bill is money bill or not? So हम देखेंगे friends money bill क्या होता है. So who declares that it is a money bill? Who is the final authority to decide whether the bill is a money bill or not? This is the meaning of the question. So friends, the speaker of the Lok Sabha has the final voice if the bill is money bill or not, in declaring if a bill is money bill or not. So what is money bill first of all? Friends, in very simple terms, if we'll talk about what is a money bill, so it is any matter concerning with the direct revenue of India falls under money bill. कोई भी बिल ऐसा होगा जो रेवेन्यू से डील करता हो, हमारे देश के आय से डील करता हो, रेवेन्यू से डील करता हो, वो होता है मनी बिल. Okay, and if question arises whether a bill is a money bill or not, Article 110(3) says that the decision of the Speaker of the House of the People thereon shall be the final. So House of People is Lok Sabha. Lok Sabha के speaker की ही final voice होगी if the bill has to be declared as a money bill or not. Moving forward, next is another question on money bill. So money bill can be introduced in, friends please note it down, money bill सिर्फ और सिर्फ लोक सभा में ही introduce हो सकता है. Let's see the PTN. So as per Article 110(1), money bill can be introduced in Lok Sabha only, that is the lower house. Rajya Sabha cannot make amendments in a money bill passed by a Lok Sabha. अगर लोक सभा से पास हो गया है, राज्य सभा उसमें amendments यानी changes नहीं कर सकता. And all Rajya Sabha can do is suggest amendment to the money bill. सिर्फ उसमें कुछ changes suggest कर सकता है, खुद से amendment नहीं कर सकता. Moving forward, another question. A money bill passed by the Lok Sabha is deemed to have been passed by the Rajya Sabha also when no action is taken by the upper house within. So upper house is Rajya Sabha. अगर राज्यसभा 14 दिन के अंदर कोई एक्शन नहीं लेता है या अमेंडमेंट्स नहीं बताता है तो वो बिल अपने आप पास हो जाएगा. So money bill is deemed to have been passed by both houses if it is not returned by Rajya Sabha within 14 days. So this is the limit of the days. And if a money bill is returned by the Rajya Sabha without any recommendation, it is presented to the president of our country for his signature or for his assent. Okay. So do remember 14 days is the timeline for Rajya Sabha to give any recommendations or keep it with itself. Moving forward. Next is, which of the following is an incorrect statement? Friends, out of these four, we need to find the wrong option. So, the Vice President of India is the ex officio chairman of Rajya Sabha. Friends, this is the correct option because the Vice President is the ex officio chairman in Rajya Sabha. Next, Rajya Sabha is subject to dissolution and is not permanent. This is a wrong statement, friends. Rajya Sabha is permanent, it is not dissolved. Okay. Rajya Sabha currently has a maximum membership of 245, that is 233 elected and 12 nominated. This is a correct statement. Article 84B provides that the minimum age for becoming a candidate for Lok Sabha election shall be 25 years. So this is a correct statement. So my answer will be B. Okay. Moving ahead. Okay, let's see some PTN. So Rajya Sabha is a permanent body, as I told you, and it is not subject to dissolution. And one more very important thing, however, 1/3 of the members retire every second year from Rajya Sabha and are replaced by newly elected members. Okay, and each member is selected for a term of 6 years. So after every 2 years, that is 1/3 of the members retire, and the term in terms of year for one person is 6 years in Rajya Sabha. These are very important things with respect to Rajya Sabha. Please note them down. Next is, the concept of directive principles of state policy has been taken from the constitution of which country? So friends, this DPSP were taken from the constitution of Ireland. Let's see what DPSP is. So directive principles of state policies, these are the guidelines mentioned in the part 4 of our constitution from article 36 to 51 for creating a social order characterized by social, economic, political justice, liberty, equality and fraternity. So these are the main guiding principles by which the government or the state is required to make various laws and should consider these principles before making any decisions. Okay, so these are the DPSPs. Moving forward. Next, which among the following is not a fundamental right granted to us by the Indian Constitution? So friends, right to equality is a right, fundamental right. Right to property is no longer a fundamental right, but it is a legal right. And right to protest is also not a fundamental right. So my answer should be D. Both B and C are not enshrined as fundamental rights. So by 44th Constitutional Amendment, another important amendment, in 1978, the right to property was taken away from the category of fundamental rights and it was made as a legal right. So right to property is a legal right that government cannot deny that you should not buy property. So it's a legal right but not a fundamental right. And right to protest, friends, we can protest, we have the freedom to peacefully protest, but we cannot say that it's a fundamental right. ठीक है, तो आंसर होगा हमारा both B और C. आगे बढ़ते हैं. Who was the first home minister or the deputy minister of India? So both of these things would be same. So friends, deputy PM of India, the first one was A. Sardar Vallabhbhai Patel. So he acted as the deputy PM and also as the home minister for a certain period of time. And Lal Bahadur Shastri, he was the second prime minister of India. Rajendra Prasad, as I told you previously also, he was the first president of India, and presently the post of deputy PM is done away with. Now there is no such post as deputy PM presently. Okay, I guess after Lal Krishna Advani there was no deputy PM. Please reconfirm it. Moving forward. Now friends, I'll give you some important assignment question which I expect you to please answer in the comment section. So the first is, what is the question R and 0R in terms of parliament and its proceedings? So you have to tell me what are these two terms. So do find it out. Next question, who appoints the Attorney General of India and under which article of Indian Constitution. Friends, you have to tell me the person who holds the post who is going to appoint Attorney General of India and which article governs this decision. Next, which constitutional amendment is related to right to education, and also tell me the year of this constitutional amendment. Last but not the least, complete the previous sessions on polity and constitution, which you can see here. You can click it and do watch it. Now friends, as I told you, I have to give some communication to the TISSNET aspirants. So guys, I have a few past year papers and some of them are memory based. So some good students have contributed it to me. So you can easily find them on the online websites also, but if you are unable to find it, do contact me on my email ID. You can find it here, novationindia@gmail.com, or you can also contact me on Facebook or Twitter. If you're not able to find it, I'll send it to you. So because I want you guys to please have a look on it before you go to the exam hall. Okay, so we have come to an end to this session. I hope the session was helpful, and if you found it helpful, please give it a thumbs up, share it with your buddies, and subscribe to Novation for more awesome content. Best wishes from me. Bye bye.